Welcome to EUPrivacyForAll, Session 59 on GDPR, Administrative Fines, Article 79. European Parliament suggested that Article 79 would be provided with an obligation for supervisory authorities to cooperate in order to guarantee an harmonized level of sanctions. It also provided for first and non-intentional non-compliance the possibility to draft a warning in writing. Other options would be regular periodic data protection audits or fine going up to 100 million euros or 5% of the annual worldwide turnover of an enterprise. On its side, EU Council splitted the provisions in two parts. In Article 79, on the general conditions for imposing administrative fines, it provided two proposals finally retained. First, that each DPA would have to ensure that the imposition of administrative fines be, in each individual case, effective, proportionate, and dissuasive. Additionally, administrative fines shall be imposed in addition to or instead of corrective powers from DPAs. In Article 79A on administrative fines, two paragraphs determined cases in which DPA may impose a fine getting from 250,000 euros to 1 million euros and 0.5% of the total worldwide annual turnover of the preceding financial year, up to 2%. Finally, if a controller or processor intentionally or negligently violated several provisions of the GDPR, the total amount of the fine may not exceed the amount specified for the gravest violation, and it was retained. Let's stress together the key provisions of never-ending Article 79. First, each supervisory authority shall ensure that in each individual case, the administrative fines would be effective, proportionate, and dissuasive. Second, those fines, depending on the circumstances of each individual case, once again, shall be imposed in addition to or instead of corrective powers of DPAs. When deciding whether to impose an administrative fine and the amount of the fine, due regard shall be given to a set of criteria. That is to say, the nature, gravity, and duration of the infringement, and number of data subjects affected, the intentional or negligent character of the infringement, the action taken by the controller or the processor to mitigate the damage, the degree of responsibility of the controller or processor, any relevant previous infringements, the degree of cooperation with DPAs, the categories of personal data processed, and whether the controller or processor notified the infringement itself, measures taken, such as corrective powers, previously ordered against the same controller or processor, the adherence to approved codes of conduct or certification, and any other aggravating or mitigating factor applicable to the circumstances of the case, such as financial benefits or losses that would be avoided directly or indirectly from the infringement. If a controller or processor intentionally or negligently violated several provisions, as proposed by EU Council, the total amount of the fine may not exceed the amount specified for the gravest violation. There are two maximum levels of sanctions defined in respectively paragraph 3 and 3a of Article 79. Getting up to 10 million euros or 2% of the total worldwide annual turnover of the preceding financial year, concerning certain obligations of the controller or the processor, such as processes, documentation, technical and organizational measures, risk-based approach assessment, certification. Also, Such fines could be imposed to certification body or body monitoring codes of conduct. A second bucket identifies a maximum level of 20 million euros or 4% of the total worldwide annual turnover in cases based on consent not being implemented appropriately, data subjects' rights, transfers, or any obligation pursuant to member states' law regarding specific processing, and non-compliance with an order or a temporary or definite limitation on processing of the suspension of data flows by a DPA. It is specifically stressed that non-compliance with an order by a DPA could be subject to fines up to 20 million euros or 4% of the total worldwide annual turnover. Each member state may also lay down the rules on whether and to what extent administrative fines may be imposed on public authorities. The exercise by the DPAs of its powers shall be subject to appropriate procedural safeguards, including effective judicial remedy and due process. Finally, in two cases, Denmark and Estonia, legal systems may not allow administrative fines. It is addressed in a specific recital. A key provision in GDPR is recital 118b. A key point to stress in this recital is that in case of a minor infringement, or if the fine likely to be imposed would constitute a disproportionate burden to a natural person only, a reprimand may be issued instead of a fine. In recital 119, several points should be outlined. First, member states may lay down the rules on criminal sanctions for infringements of the GDPR. These criminal sanctions may also allow for the deprivation of the profits obtained through infringing this regulation. Finally, no application of this GDPR should lead to the breach of the principle of ne bis in idem, as interpreted by the Court of Justice of the EU. In recital 120, the key point to stress is that in order to strengthen and harmonize administrative penalties, due regard should be taken regarding the nature, gravity, duration of the breach, consequences, measures taken to ensure compliance, and to prevent or mitigate the consequences of the infringement. Regarding fines imposed on persons, account should be taken of the general level of income in the member state and of the economic individual situation of the person considered. It should be for the member states to determine whether and to which extent public authorities once again should be subject to administrative fines. Regarding the specific legal systems of Denmark and Estonia, not allowing for administrative fines as set out in this regulation, it is also stressed that those fines should be handled a different way but be effective, proportionate, and dissuasive. In Article 66 on the tasks of the EDPB shall, in its own initiative or where relevant at the request of the Commission, draw up guidelines for DPAs concerning the fixing of administrative fines. In Article 79b on penalties, it is also reminded that Member States shall lay down the rules on penalties, in particular for infringements which are not subject to administrative fines. Currently, the directive provides in Article 24 on sanctions that the Member States shall adopt suitable measures to ensure the full implementation of the provisions of the directive, particularly laying down the sanctions to be imposed in case of infringement. What should accountable data controllers and processors get prepared for? First, knowing that the determination of administrative fines by national DPAs will be framed by the GDPR. However, the assessment of the level of sanction will be based on each individual case. Sanctions will be effective, proportionate, and dissuasive, that is to say, getting up to 20 million euros or 4% of the annual worldwide turnover. If there are several infringements, the fine cannot exceed the one of the gravest violation. The set of criteria taken into account by DPAs to determine the level of sanction is the following one. It is based on nature, gravity, and duration of the infringement, its intentional character, actions taken to mitigate the damage, the degree of responsibility and of cooperation with the DPA, categories of personal data affected, the notification of the infringement to the DPA by the controller or processor concerned, the compliance with measures ordered by the DPA, and adherence to a code of conduct or any other aggravating or mitigating factor. Not complying with a DPA order can be sanctioned up to 20 million euros and 4% of the worldwide turnover. Member state law can frame administrative fines imposed on public authorities, but also lay down that for private entities there will be a deprivation of the profits. DPA's right to sanction is subject to appropriate procedural safeguards, including effective judicial remedy and due process. Finally, there are two specific cases, nationally the one of Estonia and the one of Denmark. So the key lingering question is knowing what will be EDPB guidelines on fixing administrative fines.